I will go ahead and call this meeting, the Planning and Zoning Commission regular meeting for May 6th to order. It's about 5:32. Roll call is the first item on the agenda. Ms. Gonzalez, will you take roll call?
Sure. Commissioner Pollard?
Here.
Commissioner Patterson? Commissioner Garcia?
Present.
Commissioner Durham?
Here.
Commissioner DeBay? Here. We do have a quorum.
Okay. Just make sure you state that Mr. Patterson is here. He just stepped out for a few minutes. Next item on the agenda is the Pledge of Allegiance. Will please stand.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Next item on the agenda is the approval of the agenda. Are there any changes from staff at this time?
No, I have none.
How about from the commission? Do I have a motion to approve the agenda as submitted?
So moved.
Is there a second? Okay. There's a first and second. I'll signify by if you do approve it.
Aye.
Ayes. Anybody oppose it? Ayes have it. Next item on the agenda is the approval of the minutes. We have it in our packet. The minutes for April the 1st, 2015. Are there any questions or changes from the commission?
No, Mr. Chair.
No? No? Do I have a motion to approve the minutes as presented?
So moved.
Second?
Second.
There's a first and second. All those in favor signify by saying aye.
Aye.
Aye. Those opposed? Ayes have it. Next item on the agenda is Citizens Forum. We allow people from the audience, if they would like to speak, we typically will give them 5 minutes to discuss any issue that they have out there that's not on the agenda to discuss. Is there anyone in the audience that would like to speak to the commission at this time? That's not on the agenda? Okay. Is there anybody that signed in? Do you know?
Chairman Garcia, we do have names on the sign-in sheet, but I believe that they're all here to speak on the case, on one of the cases.
The cases that are being presented. Yes. Thank you. Then we'll go forward. The next item on the agenda is public hearings. Item 7A is PZ 2015-17 variance that's been submitted. Mr. Louis Feinberg, who is the new planning director. Would you like to present on behalf of the town before we have the gentleman or the representative come up and speak about this?
Sure. We have. I'll just start by reading the item here. Property owner Sandra Calloway with agent Tommy Tafoya requesting a variance to place a support post in the setback for the deck built above the existing casita on approximately 0.18 acres at 223 Montoya Street in the R14 multifamily residential zone within the town limits. This is an existing structure. It has already been built. There was an agreement with the neighboring property to modify it somewhat to actually pull the deck back another 5 feet, so it is 10 feet from the property line. However, the support posts for the deck they would like to have remain in the setback. I believe only one of the posts is within the 10-foot setback. So that's the request for the variance that's before you.
And the staff is recommending
Approval, yes.
I do have one speaker on here. I do have one question. Well, I have a couple, but first, is there anybody that is opposing this? I know there's an agreement with one of the neighbors, but is there any other neighbors that are in agreement or opposing this? Or
We haven't heard from anyone. There may be someone in the audience tonight who opposes it, but
okay,
to this point, we haven't received any complaints or objections to the variance.
okay. I guess what we'll do at this point is have the agent, which is, I believe, Tommy Tafoya, who will be presenting in behalf of the owners what's being requested. And then thereafter, we'll ask if there's anybody within the audience that has any comments or want to bring up any points out there. So, Mr. Tafoya, if you'd like to come to the mic.
Okay. Thank you.
Okay. Before you speak, I think we need to swear them in. I don't know what exactly, do you know how to swear them in to testify?
State your name.
Do you swear to tell the truth?
Yeah, I do.
Please state your name.
Tommy Tafoya.
Mr. Tafoya,
Yes, sir. Thank you.
if you'd like to present what you're trying to do here.
Yes, what we are doing is we're building a deck over a casita, and I guess we have had a variance done before. And so I guess the only thing that's out of the variance is a post on the outside of the casita that will be like 10 inches over the overhangs to hold the support beam. But everything else is inside, except for the deck. We talked to the neighbor, to Jim, and he kind of wanted privacy, and I don't blame anybody else that wants privacy here, is to build a 6-foot wall so you can't see into his yard. And I'm sure this lady here would like to see that too, to her yard. Like me, I'm just a messenger here. Don't shoot me, you know. So, I mean, I'm willing to comply with the neighbors or whatever's got to be done to keep everybody happy, and the owners too themselves. So.
Let me ask you this question. You've been in the construction business a long time, right?
Yes.
You've done, I believe you've done some projects in the area and so forth. And I thought I read somewhere, and correct me if I'm wrong, but it was built before a building permit was submitted? Is that correct?
Yes.
Why was that?
Well, I had a variance, and I mean, I'm at fault to that. I should have got the permit. I thought the deck was only going to be like 120 square feet. By the time we started, it got bigger. So. Yeah.
I'm sorry, could you repeat that?
So I'm guilty of not getting the permit, yeah.
I do have a question for the town, or if somebody can explain to me. I know that there's an agreement with a neighbor of what to comply with what the neighbor's concern. Who's going to, oversee to make sure that gets done, or how? What if the owner does not comply with that agreement? Who's going to enforce that?
It's a good question. And my recommendation is for you as a commission to not even acknowledge this agreement. It's not the town's responsibility to enforce agreements between private property owners. Also, the question arises, what happens if there's a change of neighbor? Are they subject to an agreement? It's not something for the town to get involved in, other than that it's showing that immediately there won't be some kind of dispute, or at least there seemingly won't be a dispute between the two neighbors. I would advise whatever decision you do come to tonight to not take this agreement into account.
So basically what we're looking at is just a setback.
It's a setback.
It's the issue only that the
Yes.
town is looking at.
Correct.
The planning zone. Okay. Commissioners, do you have some questions?
Mr. Tafoya, has a permit been issued now?
No, we'll be getting permits if we get approved tonight. So we will go through the permit process if we get approved.
I think you need a permit whether you get approved or not.
Yes,
You
yes,
build
right,
something there.
right.
But,
Right.
okay. Thank you.
Yes, sir.
Any other questions? Do I have a motion? to the variance PZ 2015-17.
I'll move approval.
Is there a second to that motion? I will second that motion. Discussion.
I was trying to look on the site plan to figure out where that post was that we were putting in setback. So the site plan that we have doesn't seem like it really, it's a survey.
On the shed here,
So it's and what's the setback supposed to be?
the setback, well, the property line runs every which way here. Here we have 7 feet, and here we have 6 feet. I mean, like 5 feet. So the post is right here.
The casita is all
The casita is under here. Yeah, that's a carport that we had a trailer for. So the gate is right in this area. But the reason we want that post there is so it's a point for the beam for the deck.
That's the post that goes in the setback.
Right.
Okay. Good. Thank you.
I have a question.
Yes, Dubé?
Mr. Tafoya, I noticed that there is a shed built back there as well. And
Yes.
it's written into the agreement that we're not going
Right.
to deal with.
Well, the shed is it's an 8 by 6 shed, and the neighbor has no problem with that shed being there. So, but we asked him if it's in the way. If somebody's got a problem, we can move it somewhere else, but it's only 6 by 8.
The thing that I saw that I was concerned about was, if you look at this picture, these are great pictures, by the way.
Yeah.
There's a gentleman standing there, and it looks like he can just barely squeeze in between the fence and the shed. And I'm thinking to myself, what happens if a fireman needs to get back there?
Yeah. Well, the shed can be moved back or else somewhere else in the property.
Yes.
Question for Louis. Is the shed in the setback in violation? Can you have accessory uses in the setback or?
That's a good question. And I can...
Just to interject, it's not on a permanent foundation, right?
No, I believe it's under the amount required for a permit or for a building permit.
Right. Generally, the setback requirement will say what's allowed in the setback, and sometimes accessory uses are, sometimes they aren't. And I was just wondering whether the shed violates.
If you don't need that answer immediately, I can get it.
Okay.
Get it for you.
It's not really part of the request before us tonight, so
Exactly.
there was more curiosity.
The applicant is amenable to moving it at any rate, so if there's an issue.
Any other questions?
No further questions.
Okay. There is a motion on the table. There's a first and second. Ms. Gonzalez, will you take roll call?
Commissioner Pollard,
Aye.
Commissioner Patterson,
Yes.
Chairman Garcia,
Yes.
Commissioner Durham,
Yes.
and Commissioner DeBay.
Yes.
Thank you. And I think somebody wants to speak on behalf of that too, so one of the neighbors. So. Thank you, guys. Thank you very much.
I apologize for that, but you're welcome to come up to the podium if you want to discuss that. I missed that. I apologize.
I have a problem with what's being built because the neighbors, and they're good neighbors, I like them and everything, they built this 8-foot fence around their property, and now they're going up. So where's my privacy? Are they going to build a 50-foot fence to cover towards my house so I can have some privacy? If Mr. Tafoya would have contacted us during the permit process, a lot more people would have complained. But since we didn't, or he didn't, this is what I'm stating.
And I apologize for not allowing you to speak. I dismissed that. But and I'm only one commissioner. But the neighborhood, unfortunately, some have been grandfathered in. So that's part of, I think, from my decision-making, that's what,
That they can build whatever.
unfortunately, well,
So I can go ahead and build a 2-story house, a huge monstrous.
well, you still have to come over, and we got to look at the safety
But-
issues to that, but you're right.
But I can go ahead and do that.
Well,
Build this huge fence and cover them up, and then they're going to come and complain to you that I disturb their scenery, or they can't see the trees, or anything like that. And that's what bothers me.
That's what bothers me.
Ma'am, I'm sorry, I didn't hear your name.
Lorella Salazar.
Loretta Salazar.
I live south.
Is this a new fence?
Well, they built it, Tommy built it when he did the remodeling, and it's an 8-foot fence.
Well,
6, and we can't see into their.
well, I believe that the 8-foot fence is in violation of the town code.
Well, the one
So-
west of me is a little higher than that.
We
So they
didn't-
all have fences around their property and stuff. I don't have a problem with the fence. It's the going up. They're going to sit up there and drink their margaritas looking at everybody else. So where's my privacy? And in order for me to have privacy, I need to put a tent.
Unfortunately, in the zone that you're in and in that part of town, they would have been allowed to have built a 2-story structure, for example, if they were building something new. So it would have also been looming over you.
Yeah.
The underlying zoning, I think, is what did allow this. The 8-foot fence is not allowed by the code, and I think you may have some recourse by going into the town officials to complain about it if it's new.
But still, they
Well,
built,
you don't have to, but you have
they
the...
still built some condominiums west of where I live, or east of where I live, and I had problems with them because they have a balcony, and kids were going up there, people renting or whatever. They were shooting my windows, and my windshield with BB guns. So,
That's not right.
but that's my complaint. And I thank you.
Okay,
Thank you.
and we will reflect that in the minutes as well, the comments.
Lorella. Lorella. Salazar.
Okay, next item on the agenda is item 7B, annexation of PZ 2015-18. This is property owners of John F. and Sarah Jean Norris, with agent Mark Yarovitz petitioning for an annexation of approximately 19.3 acres into the town of Taos. I will submit it to the town and the planning and zoning director to give their findings and their recommendation.
Okay, this is the property owner, John F. and Sarah Jean Norris. I'm sorry, I'm getting a little feedback here. With agent Mark Yarovitz are petitioning for the annexation of approximately 19.3 acres into the town. The property is located on Camino del Rancho Arriba and is currently located in Taos County. Staff is recommending approval of the petition subject to the recommendations outlined in the staff report. Those are that, 1, all residential units constructed on the property shall be required to connect to town utilities. That would be water and sewer. The ultimate developer of the property shall be responsible for all costs associated with the extension of utility infrastructure to service the annexed property. The applicant shall prepare and submit an annexation agreement to the planning department for review that includes the conditions outlined in 1 and 2, and that the annexed property should be zoned to R4 residential in its entirety, which would be the subject of the following item.
Okay. I know that we do have, any questions from the commission at this time?
Mr. Chair, would it be possible to hear both at the same time?
Sure.
Just to...
If you want to present the zoning as well.
So it would be item number C under public hearing, so we would be hearing both simultaneously. Property owner John F. and Sarah G. Norris with agent Mark Yarovitz are requesting a zone designation of R4 residential for approximately 19.3 acres, contingent upon Planning and Zoning Commission approval of annexation PZ 2015-18. Subject property is located on Camino del Rancho Arriba and is currently located in Taos County.
I would like to state within that that it also requires the Town of Taos Council to approve the annexation.
Correct.
Okay, so it's not only the commission itself, but the council as well on the annexation. Okay, let's go ahead and hear from the agent, which is Mr. Yarovitz. If you will state your name and if he can be sworn in.
My name is Mark Yarovitz, and I swear to tell the truth.
So if you like, Mr. Yarovitz, if you would like to present what you've submitted, and we'll take it from there.
The owners of the property, the Norrises, have owned this property for many years, and they are getting on in the years, and have asked me to go ahead and assist them with what we call repositioning the property. They would like it annexed into the town limits for a couple of reasons, but mostly they do anticipate selling the property sometime in the future, and they would like to do it with the annexation into the town. One of the issues they would like to resolve prior to doing anything is the access to the La Lomita trailer court, which is part of this 19 acres, is less than substandard. As we met with the DRC committee and I met with the fire department, et cetera, the access in and out of La Lomita trailer court is narrow and difficult. So one of the things they would like to do as part of this is to realign a new ingress-egress along the south side of the property and come out on Camino Rancho Arriba. And in order to make it, for health and safety issues, to access the existing La Lomita trailer court. And the annexation is what they wished for. There is a main sewer line also running down that property line, and I don't think they're on town water at the moment. They're on a private well, and they were considering some of those issues at the same time. The question for the R4 is, you can see that the property adjacent and around it is R4, which is the appropriate zone for this project. Even if it were to remain in the county excuse me, has an ordinance that allows 4 units per acre if you have access to the town sewer lines. So it is currently a de facto R4 property if it were to be developed in the future through the county anyway, but they thought that the services from the town would be superior than dealing with the county, and there was a fire hydrant nearby, the sewer line and the water, et cetera, and they thought it made sense to annex and do the R4 zone change. There are currently no applications or plans being submitted to the town for any development purposes. Their family members and them discussed what their options were, and they do intend to sell the property at some time in the future, and annexing it with an R4 zone change gives the next buyer some clarity in terms of what he may or may not do. And that's what I have for now. Well, I'm happy to answer more questions.
Commissioner DeBay?
You go ahead.
Is it their intention to hook up to sewer and water now? Or is it just to...
The main sewer line, I believe, is now accessing some or all of the trailer park at the moment. I'm not sure if all of it has been done. They haven't really pursued, there are many vacant spots in the La Lomita trailer park now, and they haven't pursued filling it up. And I wasn't sure because they were going to extend the sewer line to the vacant lots or not. They really haven't done anything with it for many, many years. It's been somewhat neglected.
I'm just trying to seek clarity so that we're sure. To annex the property into the town, we have to give it a zone. You're correct, it's going to be R4. And there are certain requirements that go along with that. Most of which I think have to do with looking at what the long-term plan is. I'm not able to see clearly that you can just put R4 on a piece of property this large and leave this many residences on it without doing some planning, if I'm making myself clear. It looks clear to me in the law that you need to obtain this, you need to hook up to sewer and water, to town utilities. So that seems to me that you have to, well, maybe I can read, you look quizzical.
I'm not sure you're saying that in order to get annexed and an R4, they're required to hook up all the
To
existing
get annexed
units
into
to
the
sewer and
town,
water.
regardless of the zone, you need to hook up to town utilities.
Sewer and water. And
Yes.
that- if it's already existing or for new construction?
Well, it just says that you have to hook up to town utilities, and then,
When you annex the property.
yeah. It's been my experience in the past that
Okay.
existing or new, you need to then hook up, or at least have a plan and then perhaps bond for it if you're going to be doing it at some point in the future.
Correct.
So I think we're going to need to try and address that. The other question that I have is, you're not looking for a subdivision. You're going to leave it as a manufactured home park. Is that correct?
There's no plans for changing the status quo of what it is at the moment.
Okay. I think in looking at the requirements for the R4 zone, under permitted principal uses, you have to have the manufactured homes on individual lots, or you need to do conditional use. So you need a conditional use permit as well.
To grandfather in what's there?
I don't think, because you're asking for a zone change, I'm not a legal expert, but I'm just following what I'm seeing here, and I believe that you can't come in as a non-conforming use without permission. Of course, that seems another sort of a conditional permit at this moment. But the R4 zone, to annex the property and to petition for an R4 zone, you have to meet the requirements of the zone, or the property owner will need to do that. And under 1616-100.2, it says the manufactured homes should be on individual lots to be a permitted use, or you petition for a conditional use permit, which is 1616-100.4. And one of the conditional uses is just this: it's a manufactured home park,
Correct. Has a
provided
PUD.
that it's developed as a planned unit development according to, which means more drawings and more plans and road.
I have to ask clarification here. So what you're saying is that if this are to be approved, the existing mobile home park has to be upgraded prior to approval? Or it
No,
cannot be?
I would have thought, and I may be wrong, and the commission probably has an awful lot of latitude here. In the past, when I've seen things like this come up for a planned unit development, annexation, and a zone change, it's usually accompanied by a plan as to what the developer is going to be doing, and that's why they're asking for the change.
Right, but they don't have any, there's no current plans on the table for doing anything yet prior to this approval process. Otherwise, if there were some, they'd be dealing with the county and not the town, so they'd be a different set of standards. So they really are just positioning themselves to sell the property to the, as the staff report says, to the ultimate developer who there is no buy.
I think that without a plan on the table, from just my point of view, and there's a lot of other commissioners up here, what might happen is that the property gets annexed into the town. It gets annexed as R4. A great economic benefit accrues to the owner and their position to do things. But there's no protection that the homes would be connected to sewer and water, or that access issues will be taken care of.
The existing homes or the new ones? That's where I'm confused.
There's no distinction in the code. In the past, there's no distinction in the code that I can see.
I don't.
Maybe what we need to do is direct this to the town and to the planning commission and or the department with the attorney to get some clarification on that, because it's a cloud at this point. Because I do have a question about, there's 30 mobile homes there now, but it has been approved for 40. So does it grandfather 40, or is it the 30 that are sitting there right now? So there's some kind of, some clarification that needs to be done in that point of it.
True, I would like some
I'm just not
some
certain that you
clarification,
get an
too.
automatic grandfather. That's, I don't know that we have the opportunity to look at this.
There have been cases that I'm aware of where things have been annexed into town and grandfathered before. For instance, the Draperville project is a live-work project that was developed in the county and then annexed into the town and grandfathered as is. I know that for a fact. So there has been precedence on that.
And was there a zone change as well at that time, or?
Well, when you annex anything into the town, you have to
put
create a
something,
zone. So everything, I wouldn't know if this is not a zone change, it's a zone creation. Otherwise, your default position is RA20, and you do see on your master plan for the town of Taos many white spots on your zoning map which were annexations without zone changes, and I think that's inappropriate in itself. But on that other project, when you annex in, you do have to create a zone for that is appropriate. So I am aware of that situation.
Mr. Dare?
Yes. Commissioner Pollard, I think your concerns are legitimate and valid. I'm wondering if, because there's going to be an annexation agreement, if that might be the proper vehicle for requiring that future development occur under the R4 standards. I see Mark's difficulty in terms of to zone into R4. I don't think, I have to be careful how I say this, but on an existing project like that to be zoned R4, if each of the units is not on an individual lot, that might be in nonconformance with R4. I was reading the R4 more to be a guideline for future development. But I'm just wondering whether maybe Lewis, working with the town attorney and Rick, could take the concerns that have come up tonight. They're mostly procedural concerns. I think the
I'm not sure, Mr. Durham, and I have one more question. And I agree, this is a complex problem that needs to be addressed. It looks to me clearly, though, that to grant annexation, regardless of the zone, you must be connected to city utilities. You must have a plan to do that. That looks clear.
The sewer line is connected. I'm pretty sure. I don't know about the water.
Okay, so I think that's got to be a condition to be able to go forward, that whatever's there.
I believe that can be addressed as part of, within the context of the annexation agreement.
Okay.
And I will confer with the town attorney about the specifics of this, but I believe if there are no units to connect to, the requirement that the connection be made prior to annexation is probably a little cumbersome.
Yeah, I wouldn't. Normally, I think.
But I think that can be addressed within the context of the annexation agreement. Regarding the existing trailer park, if you did choose to annex this property and zone it R4, it would be a non-conforming use.
Yeah, it's clear that the existing trailer
and
park,
any future development going forward would be bound to the requirements of the R4 zone.
The existing trailer park was developed many, many years ago, and I doubt that it would have been, if it was in the R4 zone today, it would not be approved as it looks today. There's no question about it. But it was developed, and even in the county, I think they have newer rules and considerations that if it were developed even in the county, it would not look like what it was. The access itself is narrow and difficult.
Can I ask one further question? I'm looking at the survey from Eagle Peak, and is this an acequia system coming through?
Those are 3 or 4 different laterals that all end on the property. There's no flow through past the property. That all comes up from, it's the, should know the name of the acequia. Los Lavatos, thank you. And I did walk the property at one time with the mayor domo to ask him about those laterals and what they were doing and what the issues were, and he said those were all dead-end laterals on the property.
So, all right. So you're saying then that there's probably no need to take those into consideration into a development plan?
No. I'm not saying that at all. I'm saying that they have to seriously be taken into consideration. There are no concise development plans, and if they are, they have to be dealt with thoroughly, and what they're going to be doing with that.
Okay, no further questions?
What I was going to say, you said.
Oh.
When I realized the trailers were there, and then I read somewhere that it sounded, I've got to mark where I read this, but I understood that there had to be a connection to the city utilities before they're annexed.
Well, I think in the past when we've seen it done, I think in the annexation agreement, it's agreed that they're going to do it, and sometimes they'll put up a bond or given a short period of time to do it so that it doesn't have to occur before the annexation. And the town is still protected having the property hooked up if they have to exercise the bond.
Okay, it's going to be interesting to see.
If I may address the question over on SDS Road where annexation has just occurred without any zoning, there are some sewer and water lines there, and also in the Weimar area there's a new water line going in, and I just read an email that if you live in the Weimar area and there's water lines going in, you are not required to hook up to it unless it's new construction. So I've seen this issue into several different situations, and it seems to be unclear what the code requires. You're supposed to, if you're in within 100 feet of a water line, you're supposed to hook up to it, but I know that
I believe that's the code.
that's
I think
the code
you're right.
if with new construction. And I know they're allowing the people that live in the Weimar area, if they have an existing well and the water line's going in front of their property, they are not required to hook up to it. That was an email I just read today from the neighborhood association.
I believe that properties like this should be annexed into the town. I believe that properties like this should benefit from sewer and water. That benefits all of us to be able to do that.
Don't disagree.
I'm really leery to put my hand up and say yes to something if there's not a commitment to bring in 30 to 40 new properties and not require them to be hooked up. So I'm happy that that'll be made part of an annexation.
Well, any new construction requires the use of the city utilities, absolutely. The question is whether or not...
I'm just trying to tell you how I feel, and if I haven't misunderstood you, I'd have a hard time saying yes to bringing 40 properties, 40 residences into the town without being sure they're going to be hooked up to sewer and water.
I believe, yes, okay.
I'd be looking for that commitment.
Accept it as a condition.
Okay.
So just so I get some clarification on my end here. So what you're asking, you're agreeing, being the agent for the owner here, that it can stipulate that those existing trailers are there will hook up to city water and sewer? Is that what I get? I know what you're saying, new construction, and I understand, and I do agree with you, basically, that on new construction. I don't know on existing. They're kind of grandfathered in. If you approve, how can you force these families to hook up to city water or have the owner of the property incur a cost that maybe they're not?
Then don't get annexed. Leave it the way it is. There's no cost.
That's the question.
It's entirely possible to require through an annexation agreement that the trailer park be required to hook up to all utilities. That's not an unreasonable request.
Yeah, and I'm not trying to.
And before I commit the family, let me discuss it.
That's what I'm saying. I mean,
I was just trying to be clear. So
yes, no, I
thought I was
understand what the rules are. I don't know. They're not clear to me either at the moment.
And within the subdivision regulations of the town, it is required that future subdivisions hook up to utilities.
Well,
that's a requirement.
Yes, that's what they would want for any new construction. I don't know about the existing trailer park. I know the sewer line was brought up. There's a brand new sewer line that runs up to the area because the condominium project on the other side of that fence illegally built the entire project on top of the old sewer line, and as part of the settlement, a new sewer line was built for the Lalamita trailer court. It was brought up along their property line at their expense because they built over the old one without knowing there was one there. So I don't know about the water, though. I'm sure I don't think the water is hooked up at the moment, but I know the sewers are.
Commissioner has a question.
yes, you might want to turn on your mic. And
Mr. Yerba, what's the arrangement between the current trailers that are there and the landowner? Are they leased spaces?
Those are all leased spaces, yes.
So the individual lots are leased? So each individual trailer is a lease with the owner?
Correct.
Okay.
Yeah, and the Norrises own that trailer park, yes.
And if you don't know, could the Norrises confirm if they have town water and sewer?
I'm sure they could. I know the sewer line runs up there. I don't know if it's 100% of the units or most of them, but I know there's a private well on the property that they've been using for facilitation, and I don't know if
I don't know
the water
Norrises,
line
are they
runs
here?
there. They're not here.
They're not here.
Okay. They are?
Can we ask them if they're?
No, they're not here.
Good. Okay.
Don't you wish you owned that? Don't you wish you were the... what?
That's all. Thank you.
Chairman?
Yes.
Rick, procedural question. We're only making a recommendation for approval or denial to town council on the annexation. Some concerns have arisen tonight, which are legitimate concerns. Does the annexation agreement or contract get hammered out before the request goes to town council?
Yes.
So when it gets to council, it already has the draft annexation agreement?
Yeah, it would make no sense for any agreement to come before the council for action without having all the terms applicable.
Good.
So
that gives me comfort in going forward with a recommendation when it's appropriate that acknowledges that some of these issues can be solved in the annexation agreement.
Mr. Chairman, Commissioner, what I would suggest is treat this like any other action that you would take, in that you can vote for, against, or recommend with conditions. But you, as the Planning Commission, should identify all those conditions that you would like to be addressed. It's up to staff to develop those prior to bringing it before the town council. And I would, just as an aside, I think I understand Mr. Yarvitz's concern and the conundrum you have in regards to the utilities and the annexation and when that plays in. But very often what you can work out with the developer is they have a development timetable, no doubt, and so as not to impose a hardship on those folks that are already living there. In no sense putting utilities in that are going to come out and relatively quickly. You can say that as the condition of the annexation, if there is no development of the proposed project within 2 years or whatever time frame is reasonable, that the trailer, it's considered that it's probably not likely to happen at that point, that the use on the property now would be required to hook up to those utilities. And I think whatever that time frame is, Mr. Yarvitz could probably...
We don't have a time frame for much of anything in this marketplace, but what I would say that if there is any additional units to be developed, that would be the trigger for creating the utility hookup 100%. If they're just doing an annexation and zone change and the property sits there for 2 years and nothing changes at all, would you still require that? Is that what you're saying? Did I rephrase that wrong?
Yeah, and I want to put a slight caveat in that from real world experience, and that is when I was the planning director over at the county, we were approached by New Mexico Environmental as well as the EPA because of the concentrated number of septic systems in that area. Just slightly up the road from Ranchitos, there were wetlands there that run through the Fridays property and come all the way down from the mountain, which is a primary recharge area for the lower half of the Taos Basin. And those are all polluted at this point from the septic systems. And nobody could really afford at the time to install public infrastructure, and because of that, the state wouldn't condemn those wells or septic systems. But I do think that it just is smart planning that if there's any opportunity for the town or the county to negotiate future development, that there has to be a requirement that sanitary sewers and water are hooked up so that we're not causing further harmful effects in that area.
Agreed. Like I said, I believe the sewer line which runs up to the trailer park is connected to all or most or all of the existing units right now. It's just the water system that I think is independent.
Any other comments from the commission? At this time, thank you, Mr. Yarvitz. Anybody from the public would like to speak on behalf of this issue, please come forward and state your name.
Good evening. My name is Ethan Sockwell.
Will you swear in?
Do you swear to tell the
Ethan
truth?
Sockwell.
But do you swear to tell the
I
truth?
swear to tell the truth. One of my concerns is when the zoning changes, when it's changed from the county to the city. One of the reasons that I moved over there is because it's in the pasture ranchland area, and I'm real concerned about what it would create with future development. And I can say something specific about that. At one point, a few years ago, some developers were trying to buy this parcel. And their intention at that time was to, and I don't know if they got any approval on it or not, or tried to get approval, but they wanted to build townhouses over where the trailer homes are located and move the mobile home park over beside my home. And my mother I lived in a mobile home I'm not talking down to mobile home parks. I lived in one for a while. My mother lived in one for half her life. But to all of a sudden have 30 to 40 mobile homes moved beside me would create a little living hell instead of the little piece of heaven that I've got right now. So I'm real concerned about whether or not, if this is annexed, if it's going to allow them to do something like that, whereas now they might be restricted from doing that, because that's a beautiful area in there. It's one of the crown, I think it's one of the crown jewels of Taos. The buses used to take, before the traffic got so bad there, and that's my only objection to living there, is there's a lot of traffic, but they used to drive the buses down there that take people around on the tours, because it's such a beautiful area of Taos. And I'm certainly interested in keeping it that way, because that's where I've retired. So I guess my question to you is, what would this change? If it's changed from county area that's zoned to be pasture land and ranch land to the town zoning, is it going to open it up to a point where if a developer came in, I know Mr. Norris and Sergey, and they're nice people, but if a developer came in and bought that, would it allow them to do something like this? Good question.
If I could respond to that.
Yes.
If annexed into the town, the mobile home park would be a non-conforming use as long as it stayed like it is. If future development occurs, it has to be in accordance with all the provisions of the R4 zone. So the trailer park couldn't be moved to some other location on the property. With respect to what could happen there now, Mr. Yarovitz mentioned it, and it's correct. If hooked up to water and sewer, that property could be developed at 4 units per acre. So in that respect, an R4 zoning wouldn't be any different than what could theoretically happen there now as a county property. Did that address your question?
So if a developer came in and wanted to build townhouses, I guess they thought that it would be a lot more desirable to build the townhouses over where the mobile home park is. They couldn't just automatically move. You're saying they couldn't move that whole trailer park over the sideline?
No, they could replace it.
Yeah.
They could replace it with something appropriate for the R4 zone, but they couldn't move it to a new location on the property.
Okay. All right. Thank you.
Okay. Anyone else? Please come forward.
My name is John Rainey.
You swear to tell the truth?
I do, I swear. I am co-mayordomo of the Los Lovatos Acequia Association, and appearing with a somewhat neutral stance on this, but wanting to ask some questions with regards to the acequia, as you noted from the surveys. Our concern, and many of the members of the audience here are neighbors in the area as well as acequia members, is that with theoretical development of that, what happens to the right now approximately 17 acres of agricultural use, not just agricultural designation, but actual use of that water. And if it does get developed and gets hooked up to town and sewer, what happens to those water rights? are those transferred and then sold off to someone, et cetera, et cetera, et cetera. There's a long list of questions as to what happens to those water rights once it's switched from agricultural, not just agricultural zoning, but actual use of that. And I do want to say, I don't want to, it's kind of a can of worms, and I'm not, I know Mr. Yarovich, and we've had discussions, but I've had multiple discussions with the Norrises as owners, and I've been assured that there are plans to develop that acreage, that no plan has been submitted, but very detailed plans with the developer are already in place on how to develop that pasture land, including traffic studies where they're going to go in and out, where there's going to be parks and trails. They've got elaborate plans, and I'm not under the impression that it's fantasizing about the future, but what's going to happen after these next steps. And that Mr. Yarovich is right that no plans have been submitted in the sense that this has to happen first. You have to get the approvals for annexation and the R4 first, and then be developed. And so I think that's why a lot of the people are here tonight on the acequia, because our concern is, not necessarily what the type of structures are or the density, but when that changes from agriculture status, what happens to those water rights with regards to the association, and does it literally take water out of our hands in the valley and send it on down to Santa Fe? I spoke with Mr. Norris this morning, and he had quite specific details on what the plans were to do a development there. And so even though, and as Mr. Yarovich said probably rightly, in this market, it may be years, it may take time, but that is the intention for sure with the redesignation as R4 is to develop that. And so that's, for the acequia Association, that's our immediate question, not so much as what are the structures, but what happens to all those water rights. And it's hard to ask for the details on that since they're not asking for the development plans now, but I think it's something that has to be at least brought up officially at this stage before it gets converted into R4 to take into account what happens to those laterals. And when we did the walk, and he did with the other Mayordomo, those are the ends of laterals, but it irrigates that entire field. They currently hay that field, and so it floods the whole thing. So although it would not prevent the acequia from going on to other properties, it's not an inconsequential amount of acreage. That's a lot of acres of irrigated land, and it's not inconsequential to our association in terms of how much water we get out of the river in some pretty tricky times in terms of measuring how much water is used these days.
Mr. Rainey, in your conversation with Mr. Norris this morning, was he, I know this is third hand, but was he saying that there were development plans or that he had a picture, or could you describe that a little bit more?
He described in great detail when I say plans, I don't know that I'm referring to actual documents, but the intention and what the design of the development would be, including on the upper Anchichas corridor next to Ethan's house, having 1 acre home lots rather than the higher density with entrances off of Ariba Road, so there would be a different entrance for 3 separate sections of the R4 housing, so not trailers necessary, but manufactured homes, all situated around 3 green spaces. Because one of my questions to him was about the water rights, and if they were going to maintain water rights and uses to irrigate the green park areas, and he said there's going to be walking trails around the park areas, but he wasn't certain of what would happen once he turned things over to the developer, once he sold in combination the trailer park with the land, what would happen to the water rights after that. He couldn't answer that.
Thank you.
So I'm under the impression that it's not a fantasy of what it could be someday, but that the plan was put in place, and that this is one of the steps in the plan, and that the sale of his property to the developer was contingent on the R4 designation and being annexed into the town. I guess there's not really a question there other than our concern about what happens to the water rights.
Thank you. Anyone else? Yes.
Do you swear to tell the truth?
Yeah.
Please state your name.
Liana Bales. Hi.
Hi.
Thanks for your service. So my concern, my son literally just texted me. He's home safe. He just rode that road. There is so much traffic already. You could speak with the State Patrol because they're on it all the time ticketing people. And so my question is, if this proposal goes through and the density goes up, it sounds like quite substantially, the potential is at least, what sort of plans does the town of Taos have to accommodate this much higher traffic, because those roads are already used as a bypass for the town because nobody wants to drive the town roads anymore. And so we're already faced with, the speeding is horrific. The quantity of traffic is huge. And so you're talking about, upping that significantly, it sounds like to me, at least potentially significantly. So I would just ask that if I don't know what you'll all do, but if you do, that there has to be a plan in place for the traffic to accommodate the use that come with this. Because I got kids riding bikes on it, people are walking, there's animals. I mean, you know the story. So yeah, that's traffic.
Thank you. Anyone else? Yes.
My name is Michael Medina, not sure to tell the truth. I just wanted to make a comment. I'm one of the oldest neighbors in that neighborhood, one of the oldest remaining neighbors, and I live at 520 La Lomita, which I am in the city limits. I've been in the city limits since the town was incorporated. Now, that property was, like I say, in the city limits. When Mr. Esquivel did his trailer park, he put his entrance right off of La Lomita, which is town of Taos. And his trailer park was in the county. But all that traffic was thrown onto our street, which is La Lomita. So I'm just making a comment that you have to be very careful with this development, what you're going to do with all this traffic. Because it's already affected us since the trailer park has been there. And especially when the mine was going strong, there were a lot of people that were working in the mine that had trailers there, and that traffic was 24/7 because there were 3 shifts. There was the day shift, swing, and graveyard, and people were coming in and out of that trailer park 24 hours a day. So I'm just making a comment.
Thank you.
Thank you.
Anyone else? Yes.
Hi, my name is Peter Leonard, and I do swear to tell the truth. My thing about this is that we we abut the property. We are on the southeast side of the property, 519 La Lomita, next to the townhouse. And one of the reasons we loved this place is because of the agricultural nature of that, not all the 20 acres, but a good portion of it. And to me, Taos has a tradition of agriculture, and it seems like it's rapidly disappearing. And to make this R4, I guess that would have the potential of like 80 houses on 20 acres. I mean, is that potentially, or is there a requirement that there be green spaces, or part of it remain agricultural? That's what bothers me, is if the potential is like for 78 or 80 units, it's like taking over, an agricultural piece of land. I don't know. Well, that's one of my questions. Is there any requirement, or would there be a requirement for green space, or could that actually be 80 units?
It theoretically could be more than 80 units if a planned unit development was done on that site. A straight subdivision on 20 acres, I mean, there's a loss factor when you put in roads and whatnot. It's doubtful that many units could be built. No proposal has been submitted, but it would be something less than that if it was a straight subdivision through R4.
Okay, and if there is when the proposal is submitted, then do we get another chance to say we like it or we don't like it, or that kind of thing?
That would be subject to a public hearing.
here or in front of the council?
Both.
Both.
Yes.
Okay. Okay. Thank you.
Okay. Anyone else? I'll take one more and we'll go forward with the rest of the discussion. Unless there's someone else. Is there anyone? No? Okay.
Hi, Sonia Leonard, 519 Lalamito, and I swear to tell the truth. I guess I have a problem with us calling this property Rancho Arriba. To me, this property is on Upper Ranchitos and Caraballo. And those are two big, fine streets, and I don't even know what Arriba is. And on those two roads, we have lots of fine houses that are on huge pieces of land. The flavor is houses, big pieces of land. This is not two streets that have lots of R4 tiny four residential units on 1 acre. The predominant flavor is open space, and I think that's why we bought it 519 Lalamita. I live on almost an acre of land. We live right next to the trailer park. I love the trailer park. I've never, ever had one complaint. But I do have a complaint with the way this process is going. I feel like we're doing fast tracks. I feel like there's no discussion. I got one little letter in the mail saying, this is happening. Come to this meeting. I think that we need to have lots of studies. I just think that there's so many unanswered questions in my mind from the time frame. I mean, when you give somebody access to the city, do they have 1 year, 2 year, indefinite amount of time to hook up to the city sewer and water? The water rights was a huge consideration. EPA and New Mexico Environmental, we should see their studies before we even start discussing this. No density studies, no traffic studies. I can't even begin to think that we could come before you and ask you to vote without any information here. It really is a little disturbing. Thank you very much.
Thank you. At this point, I'm going to go ahead and close the public comment. Yes.
Can I just ask Mr. Yarovitz another
Well,
question, please?
it's the public comments, but now we'll call the representative to speak.
Sorry, Mark, are you aware of any other plans in place or any other actions that are a contract or anything that's contingent upon?
I'm not privy to all the private information between the Norrises and whoever they're dealing with. As mentioned earlier, I think a few years ago they were looking at selling the property, and there was some enormous set of plans. They told me those plans were no longer in existence, and they'd been looking at a couple other ideas, but there's nothing set in stone that I would sign my name to. I've seen cookie-cutter versions of it, of R4. I've seen a variety of townhouse designs. I've seen they looked at what is, in other words, their goal is to sell the property to a developer. What would a developer be looking at in terms of the multiple options that are available under R4, under PUD, under open space requirements, under the water rights, under the densities, density bonuses. Mr. Norris has talked about a few different sets of plans that he's looked at, and I asked him point blank, did he intend to develop the property, and he said absolutely not. The next guy will. So he said that there were, I don't know if it's currently under contract or not. It may be, but I don't know that it's there. They've been looking at this property. In fact, I first spoke to them probably over a year ago when they couldn't make up their mind in terms of what they wanted to do or go forward or not. And so finally, about a year later, they came to me and says, we'd like to do an annexation and a zone change. And I'm not, I am a realtor. I have no relationship to them with any listings or sales contracts or purchase agreements at all. There may be something that they have and they did not tell me. I don't doubt it. A lot of my clients don't tell me everything. And if there are a set of plans, I hope they hire me to develop them, but I'm not part of any real estate purchase agreements at all.
I was just curious if you knew, and
I've
I
been
don't know
around
that it's necessarily germane to the question in front of us.
I've been around these projects a lot. I've seen designs come and go, not this one, but all the projects. I'm working on several projects that have been scrapped and going back to the drawing board for the third, fourth time. I have a couple apartment projects I'm working on right now for P&Z, one going back to historical review where the whole project was semi-approved and then totally scrapped and thrown out again. So I don't see anything written in stone about this project yet. They may have something to go forward with if this gets approved. But I think they could still go forward without an annexation or a zone change from what they were talking about. So it's kind of a gray area for me, as it always is. Until the shovel's in the ground, there is no project moving forward.
Thank you, Mark.
I have a question. Yes, Mr. Patterson. Mr. Yurvitz, how can this property be developed under the zoning it has right now with the county?
The county has a subdivision ordinance of 2-acre minimums, except when you have access to town sewer, you can go to quarter-acre lots.
So this property could be developed as quarter-acre lots?
Absolutely, right now. And it has the town sewer running on the property right now. So it has access to town sewer. It would probably wind up with whether or not they would bring the whether or not they would be able to bring the city water to the county project. If it was developed in the county, they would probably be going with shared well systems unless the town approved an extension of the water line for property in the county. I'm not sure how that works. I know with the El Valle and that's a confused area for me, but they do have the city sewer line running right on the property now as a result of that settlement from before, and so with that they could develop it as 4 units per or quarter-acre lots in the county.
And we don't know currently if these mobile homes are hooked up to that sewer line or if they're on septic.
I'm pretty sure they are. I don't think they would have run that sewer line up to the Alameda Trailer Park because that's the only thing they have going there. I don't think that would have. I wish I knew the answer to that specifically, but I know it runs right up there. I believe it's hooked up to most. I can't say it's 100% of them are hooked up, but I'm willing to bet that the intent was to hook up all the trailers to the sewer line at least. I know it's on a private well.
Thank you.
Any other questions?
I did verify that particular point about density of the property being developed as a county property. And subject to conditions that you place on an annexation, I believe there is a lot of benefit to having the town review what goes there as opposed to the county reviewing it. So I think there is a benefit to annexation in that sense. This body would be reviewing a subdivision application instead of the county reviewing it.
Yes, Mr. Yurvitz. If I might address the water right question, I know a little bit about water rights, having been watching it in the Abeta settlement going on and whether that ever gets funded and delivered. But they do have water rights in the property, and one of their options would be to move those water rights into the town system and then draw that water back out for their development if they wish, keeping the water there. The physical water in the Acequias would increase to those that were splitting it because they would no longer be getting physical water onto their property. The water rights would stay. They haven't discussed water rights. Could they be sold from the property to Santa Fe? Probably. The Abeta settlement's opening up quite a bit of can of worms, and that's going to be looked at around the county as an issue. But I think that if they were doing a quarter-acre lot subdivision there, they would be required to provide either pay for water rights from the town or to transfer their water rights into the town in lieu of buying additional water rights. That would be coming from the town, and the physical water then would increase in the Los Levatos users. That would be increased physical water. But yes, the property would no longer be agricultural, and the open space is a requirement of the subdivision design. It's a 10% open space requirement for subdivisions unless you're going for a density bonus, so there is that. Like I said, somebody said, what would you do with this property? Open space, townhouses, condos, single family, all things would be looked at in terms of what the Norrises want for themselves, having owned the property a long time and they're wishing to retire and sell it, as an appraiser would say, for the highest and best use. and that's what their goal is. I'm just the messenger here, once again, as the previous applicant said.
Okay, thank you. Any more questions from the commission?
Mr. Chairman?
Yes.
I think I'm ready to make a motion if that's appropriate, but I'd like to ask a question of staff first, of either
That's fine.
Mr. Feinberg or Mr. Bellis. You were mentioning earlier that a reasonable condition that could be put on this is to hook up to, or take an action to hook up to the town utilities within a given period of time. What's the opposite of that? What would happen if they didn't conform within a 2-year period? What rights would be lost?
If you would vacate whatever the conditions were that you were granted to them in the license. So
would the annexation be vacated? Or?
The annexation could be vacated. And the benefit of the zoning.
Okay. I think we need to take.
I have
okay. Go ahead.
Procedural question for Louis or Rick. It was stated earlier that before development occurs, it would have to come back before a public hearing. What if the applicant submitted a request, building permit? I guess what I'm hearing is that subdivision comes back in front of us. In other words, is that a step? Because I know in the county, if you request a county building permit and it conforms to your zoning, there is no public hearing or further dissemination of information. So I guess I'm wondering what would trigger the development to come back before us?
I would say that it'd be advisable to construct an annexation agreement with the developer, with the property owner, that addressed all those contingencies of saying, short of replacing the existing mobile homes within the existing footprints on the property, that any new construction on the property would trigger the requirement to attach all dwellings to water and sewer. And Mr. Pollard, just as sort of a second point, though you didn't ask it, before you'd reverse an annexation, obviously the first step would be to take litigation action and to force compliance by rule of law. And I think that would be fairly enforceable and fairly easy too. Also, as a longer term policy, the town is now requiring that if you want water and sewer, for us to make it enforceable, that you have to hook up, that you have to have an annexation. We're no longer going to extend outside the town limits, because what we have learned is that under the anti-donation clause, we're extending a public benefit, which then there's no way to recapture the cost to the people within the town of extending that benefit to someone outside of the district. And as far as the water rights, I'm guessing, given the water rights, I haven't looked at it since the proposal first came up, but they would probably just, as Mr. Yarovitz said, just cover the obligation of the development on the property, particularly considering they desire increased density, in transferring those water rights to the town. And again, we'll probably put that in the annexation agreement. If there were any excess water rights over and above what the project required, we would probably put in a condition that right of first refusal be given to the Ditch Association.
Rick, I wasn't so concerned about the hookup timing. I was more concerned about some of the issues that came up tonight, the impact on the laterals, the appearance of the building, traffic report if required. Is that all part of the subdivision request? And if so, do we see that and act on it?
Yeah, it's part of the subdivision request, but I think you're also asking what happens if they don't implement the subdivision and other growth occurs there. So we can put that in the annexation agreement, that any growth that occurs other than what's already there would trigger certain requirements to be met.
Because I think the public was told tonight that this will come back in front of them, and I just wanted to make sure that was the case.
If you so wish that to be a condition, then that any development occurs and comes back to this commission, then that we will implement it.
Okay.
I'd like to make an additional comment on behalf of the protections you're looking for, is that under the Condominium Act, which is a state law, you do not come back before planning and zoning because there is no splitting of the lots. A condominium could be done on the property without you seeing it, and that goes through through the state code. So you're correct in saying any new construction, regardless if it's a subdivision or a condominium, should come back before planning and zoning for review. Otherwise, you could escape that review by doing a condo project. I've seen this happen in more than a few cases, as was the intent of the other developers to not have to come before public hearings because you are not subdividing the land, you're just pulling building permits, and the state code under Condominium Act trumps your code here. So yes, you should include any new construction or any new permits as part of your condition for protection.
I have a question. The trailer park cannot be built in an R4, is that right?
Not unless it's a conditional
use.
Planned unit development.
Right.
Okay. I was just looking at this skyline picture. It looks to me like maybe we don't want to annex the trailer park. It's in the county at this point, right?
Yes, entire property.
Okay, so I'm just trying to clean up the thing. It looks like it's going to be just a mishmash at this point. If the owners of the trailer park would consider not including that into the area that's annexed and just leaving it where it is with a better access, does that clean up any of the questions?
I don't know the answer to that, and I don't know if that's possible. Do you have to do a lot split to do that, or can you annex a portion of a property? You would have to split the property in the county and annex, the county as well as anyone. So I don't know how that works.
I think one of the state requirements is what they call an annexation plat. It's a legal survey of the area to be annexed. So I think there is a vehicle to do that.
Is that an exemption from the subdivision, or do they still have to do?
I don't believe so. I think it's
I wouldn't recommend annexing a portion of a property.
And I wasn't supporting, I was just responding that there is a legal vehicle for defining the area to be annexed, and it's part of the annexation
I understand
requirement package, and I don't think that would require a subdivision. That's just my...
So it's going to be zoned R4, but this trailer park is grandfathered in, right?
Right, and you can do under the code, you can do a mobile home PUD in the R4 zone with 2-3 pages of requirements in order to do so.
Okay.
But yes, you can. In fact, there's only 2 zones in the entire town limits that allow mobile home parks, and it's R4 and R6. Okay. And they have very stringent requirements in order to do so, and they have to be done as a PUD in addition to the process. But the question you're asking is interesting because I don't have any idea how to do that other than having the owners of the property split that in the county prior to annexation, which would be their administrative split of some sort. I don't know if they would want to do that or not, but I think that's the only way to do it. Is that correct, Mr. Billis? Yes?
Just to make a comment on that,
is that the intent?
I think that the reason we're talking about R4 is because the adjoining properties or certain properties are already zoned R4. So starting to cut properties and leave a little portion for county doesn't make sense to me.
No, I'm not recommending that.
Yeah.
Just as a comment in terms of the neighborhood being wonderfully large homes, the property immediate to the south of this project, I believe, is 18 townhomes on 4 acres. Those are not 1 acre parcels. Immediately adjacent to this parcel and immediately to your next door neighbor there, that project is certainly not 1 acre lots.
Mr. Yarovich, I think we've had enough discussion here, so I think that
One of the commissioners does have a motion that we need to do this separately, so item 7B, annexation, if you have a motion for that.
Yes, Mr. Chairman. In the spirit that I believe it is a better thing that we bring this property into the town and be able to control health, safety, and welfare, regardless of how it gets developed in the future. I believe firmly that I'm going to make a motion that helps bring that development approval back to both the Planning and Zoning Commission as well as the Town Council. In addition to the findings of fact that are listed by staff, which I'll repeat for the public, the property consists of approximately 19.3 acres. The property is currently in Taos County. The applicant has petitioned for annexation of the property into the town limits. There's a mobile home park located on the property. The property is immediately adjacent to the town of Taos boundaries. The subject property is adjacent to properties with an R4 residential zone designation. I would like to add, based on that, with the two conditions that any new construction on the property needs to come back before the Planning and Zoning Commission and the Town Council for review and approval, and that some action needs to be taken or resolved with the town of Taos regarding the hookup for sewer and water within a 2-year period of time. I move that we recommend to the Town Council to annex the 19.3 acres.
We have a motion on the table. Is there a second?
I'm happy to second, but if I may add.
So there is a second. Discussion.
Okay. There were 4 staff recommendations, and I'd like to make sure those get into our recommendation for approval. And those are that all residential, do you see them or do you want me to read them?
No, please, go ahead.
There were 4 staff recommendations. All residential units constructed on the property shall be required to connect to town utilities. Ultimate developer of the property shall be responsible for all costs associated with extension of utility infrastructure to service the annexed property. The applicant shall prepare and submit an annexation agreement to the planning department that includes the conditions outlined in 1 and 2 above. And finally, the annexed property, we're not discussing zoning, but one of the conditions,
we'll discuss that.
I'll leave condition 4 off because that related to zoning.
Just one minor point. In item number 3, the last 2 words, review and comment, I think you should just include that. Make sure that gets included. You want a chance to review and comment on the annexation.
Okay.
Oh, I see. I think the 4 recommendations.
The findings of fact you read were the.
Sorry, I was reading off the wrong page. Excuse me, I was reading off the zone change. That's correct. I would accept those modifications.
Okay. So you agree with that and you second those changes?
Yes, sir. I second.
Okay. Ms. Gonzalez, will you take a roll call?
Commissioner Pollard?
Yes.
Commissioner Patterson?
No.
Commissioner Garcia?
Yes.
Commissioner Durham?
Yes.
Commissioner DeBay?
I'm going to say no.
3 votes against 2.
So it passes. Okay. Next item on the agenda is 7C, zone change. Do I have a motion for that?
Mr. Chairman, in the matter of case number 2015-19 regarding a zone change, based on the findings of fact as listed in the staff report, and based on the condition that any new construction on the property needs to come back before the Planning and Zoning Commission and the Town Council for review and approval, I would move that an R4 zone change be recommended to the Town Council. Or R4 zone be applied to this zone designation.
I'll second that.
Okay. Any questions? Any discussion?
On the previous vote, were there a majority in yes?
Yes. 3-2.
I keep thinking we need 4.
No, we have 5 members, so we have quorum,
Okay.
but majority.
So 3 is your majority.
Yeah.
Okay.
So we,
Chairman,
yes.
I think my only comment regarding the zone change is that the property is currently a large open agricultural property, and I don't see the R4 zone as being a good designation for that property. I think a more proper designation for that property would be something that retains more of the agricultural open space, and I'm not sure what that would be, if it would be one of the RA zoning designations. I'd have to go back and look at what they are. But I think extending an R4 zone to the entire property just builds it out to a density that isn't necessarily consistent with the town's intent for land use.
Any comments?
Discussion period. I would agree with what you said on the surface, but I believe that a property of this size is only going to come back to us as a subdivision with requirements, with open space requirements within the Subdivision Act, or it's going to come back as a planned unit development. In any way, shape, or form that it comes back, the open space and the acequias and the agricultural use of this land has and will be dealt with. I'm firmly convinced of that, so I'm not quite so worried. I find that because R4 property does surround it, it is more contiguous at this moment. This is a large piece of property, and I believe it's going to be treated specially.
Any other comments? So there was a first, and the second, there was a second, right? Okay. Ms. Gonzalez, will you take roll call?
Commissioner Pollard?
Yes.
Commissioner Patterson?
No.
Commissioner Garcia?
Yes.
Commissioner Durham?
Yes.
Commissioner DeBay?
No.
We have 3 yeses and 2 noes.
Make it reflected majority to pass it. Okay. Next item on the agenda is item 8, matters from the staff. I'm not sure if there's any discussion or indication of any comments needed to be relayed.
There's one matter I would like to discuss. I have drafted an ordinance for the regulation of medical marijuana dispensaries and facilities that we would like to review. And I wanted to see if you were amenable to a special meeting prior to the next regular meeting devoted to reviewing that ordinance.
And the special meeting would be to just discuss basically the intent of the regulation or the ordinance?
It would be to discuss actual language. You would be presented with a copy of the ordinance. It includes where they can locate within the town, hours of operation, general requirements that they need to abide by. It's the idea that we should be proactive with regard to citing them as opposed to being reactive.
Is it something that the attorney will review before we
Yes.
convene?
The attorney will review and should submit comments, and we would then present those comments to you, or hopefully they would be incorporated, his comments would be incorporated prior.
Any comments? The coming month, dates that would work for
If you're amenable to the concept, we can arrange the date by email for the special meeting, and then we can make sure we meet all of the noticing and advertising requirements.
I'd like to request, if it sits with anybody else, I'm used to Wednesday evenings like this, and I've kept Wednesdays open. I would ask if we could do it Wednesday at 5:30.
Is there a general feeling?
My only conflict was I sit on County Planning Commission, and we meet the second Wednesday of the month, so that wouldn't work for me.
Okay.
The second or the third?
We could do the third?
Oh, yeah, I'm sorry. I'm thinking historic preservation. Never mind.
Oh, okay, good.
Are you on that too?
No. I attend and am vocal, but I don't get a vote.
Oh, okay.
So if you could avoid the second Wednesday of the month, that'd be
We have
great.
historic preservation on that day anyway, so
Okay.
that probably wouldn't.
We'll let you shoot out an email and see what's best for everybody. It's hard to say on reference without looking at a calendar, but unamendable to the meeting.
Worst case scenario, we could put it on the agenda for the next regular meeting.
Mm-hmm.
Worst case scenario. But I think the idea is we want to get this approved and in place. So
You might have a lot of public comments as well, so keeping the one item separate from a regular meeting might be best. Yeah.
Are there projects in the pipeline for June?
Did we have any?
Isn't Mark coming back in June?
Yes, those. Yeah, his
There are
case was
projects.
continued.
Oh,
That's a big one.
That's a big one.
That's a big one.
Yeah. Okay.
I might as well tell I won't be here in June. I'm sorry I'll miss that big one.
Okay.
Okay, so we'll try and work out a date before the next regular meeting.
Okay.
All right. Next item on the agenda is the matters from the Planning and Zoning Commission. Any commissioners have any comments or anything they want to share? I do have one. Mr. Bellis, there was a letter addressed to you, I guess, but it was CC'd to me. It's from Patrick Nicholson.
Yes, sir.
If that can be, it's asking for somebody to respond to their concerns, and I don't know if you have, maybe you have, but I just want to bring that to your attention if you will follow up if it hasn't been addressed, either yourself or the director.
Mr. Chairman, there have been 2 meetings, one of which included Councilman Hahn, the mayor, and myself with Mr. Nicholson to explain to him that how that development occurred, and that it is not within our purview whether it was correct or not to go back, given that prior planning directors and officials gave permission to that project. We can't just reverse that without having to pay compensatory damages, so the chances of that are pretty slim. And so I've seen that letter for over a year now, and I believe that you'll also see it appear in Mr. Whaley's column, which is why you got a copy of it suddenly, and it's been circulated for political purposes. It's been more than answered to the satisfaction of the town attorney.
It's just that it's dated April 29th, and if you met with them, fine, and we'll go
Probably
forward.
about 7 months ago, and then about 4 months ago when Mr. Nicholson was not given the position as planning director.
Okay.
Can you, what's he talking about in that letter? I haven't.
He's indicating that basically it's a single-family residential zone and that there was a duplex converted into a fourplex illegally, and that there were no approvals, and it should have been red tagged that there was no building permit. There was a delay in actually getting a building permit for it, but by the time we became aware of that project, there was a building permit on the project. It was CO'd. In addition, the planning director did approve the project as consistent with the zoning in that area under certain conditions that were granted to the project.
Okay, thank you.
Okay. Any other comment?
Welcome, Louis.
Yeah,
Nice to
Mr.
have
Lewis.
a planning director again. Glad to have you here.
Just one other point. We are moving. You may have noticed that there are a lot of unzoned areas of the town. We're taking steps now to bring that in front of you for zoning.
Great. It's nice to have someone that we can lean on. Next item on the agenda is adjournment. Do I have a motion to adjourn?
Could I ask a question first? Sorry. The thing from the state of New Mexico, Department of Insurance,
I'm not sure if Mr. Bellis has
Bellis?
seen that.
have you seen that letter?
There was correspondence that was in my packet, and that was one of the letters that was there. And it doesn't show it's addressed to you. It's addressed to the owner of the business, the bonds business, in reference to a case we reviewed a few months ago, and some steps there. So it's just more information for you and maybe having our attorney look at it, but it's something that the state is addressing with the bondsman in reference to the issue.
I have not seen this, but we will take action on it.
Okay. Well, okay.
Thank you.
Okay. Motion for adjournment. Is there one?
I will.
Oh, okay. Second?
Second.
All those in favor signify by saying aye.
Aye.
Ayes have it. I'm not even going to ask if there's any nays. Thank you all.
It's been an interesting night.